Hello, my name is Michael Tesoro and welcome to 2025. As you can see, this is the ACCC cheat sheet for October 2024, which indicates I'm a few months behind, trouble keeping up. What I'll be seeking to do is to catch up in the next month or so, and hopefully by the end of January I'll be back on track. I guess for people who haven't seen it before, effectively I'll be summarising the major ACCC developments in the month of October 2024. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been running my practice as Saro Legal Consulting for quite a long time now, probably 16, 17 years. And I help companies, individuals with competition and consumer law matters. I also do some other work, a bit of consultancy work and competition consumer law for some legal publishers, and I'm also a general member of NCATS, New South Wales Civil Administrative Tribunal. Prior to that, I worked at ACCC for 15 years, did a variety of things there, including Director of Enforcement, in charge of the Sydney Mergers and Asset Sales branch, the two roles that I had. Now, the outline's pretty straightforward. There's courts, there's one court case, one significant enforcement action, quite a bit of merger activity. The big law reform was the introduction of the merger changes to Parliament, which subsequently were passed. Some authorisations, not as much as usual, and definitely not as much inquiry and consultation work as usual. A couple of interesting other things. Now, the big case for October was the settlement of the ACCC Qantas case. And if people can remember, this was where Qantas was effectively selling tickets after it had cancelled various flights. And initially, when the case was run, Qantas came out and was very bolshy in their response to the ACCC and ran some interesting arguments that they didn't apparently sell passengers tickets to planes. They sold them a bundle of rights, and that was roundly condemned in the media. I think people thought it was a pretty silly argument. And Qantas probably should have gone straight to a settlement here because they were never going to win this case. It just got a bad reputation for a while now. But also, I think the breach was quite straightforward. So it's the kind of case you don't really muck around with. You just go in there and settle it as quickly as possible. As it turned out, they consented to an order by the federal court that $100 million be levied against them in penalties, which is a very, very big penalty. It's not the biggest for a consumer breach. It's probably the second biggest penalty that's actually going to be paid. So the other one was Volkswagen 125. There are a lot of other big penalties against VET providers, vocational education training providers, but they're Phoenix fines, as I like to describe them. They're never going to be paid because the company's liquidation. So it's a big fine. A lot of people are saying that probably it should have been bigger, but you're not going to really get over $100 million by consent, at least at the moment. Maybe in the future you will. So the penalty was for misleading consumers by offering and selling tickets for flights that had already been cancelled and by failing to promptly tell existing ticket holders of its decision. There was a bit of a suggestion here this might be an anti-competitive conduct by Qantas, that it didn't really want to allow customers to switch to a competing airline, but ultimately was run as a consumer law case. So Qantas admitted that it contravened Australian consumer law and agreed to make joint submissions that $100 million was the appropriate penalty, and the judge signed off on that. Previously, on the 5th of May 2024, Qantas gave an undertaking to ACCC to actually pay some compensation to various consumers, $20 million approximately. So this is going to go to customers who purchased tickets on Qantas flights and decided to cancel and incurred various losses as a result of that conduct. And Qantas admitted in the case that senior managers were responsible for different aspects of Qantas' systems and operations, and that they knew that cancelled flights were not immediately removed from sale. So not only did they admit a breach, but they admit knowledge of the breach. That some consumers booked tickets for flights that had already been cancelled, so managers knew that. That existing ticket holders were not immediately notified. So all this was knowledge that the management of the organisation had, and this was obviously something the ACCC pressed for, and ultimately Qantas agreed to do that. Qantas also admitted that it benefited from the conduct by obtaining revenue from consumers who had chosen a cheaper Qantas flight or a flight with another carrier had they known their chosen flight had been cancelled. So these customers sort of stayed with Qantas, didn't go to competing carriers. They benefited from retaining revenue from consumers who were less likely to change carrier when they were eventually notified of the flight been cancelled. So these are significant. The interesting thing about the case was it wasn't actually anybody from Qantas who got on the witness box and apologised for the conduct. Rather, it was their barrister, Ruth Higgins, who apologised on Qantas's behalf. And that's not a good look. You've got to really get somebody there from the business to apologise to consumers in the court. So it's a strange thing to get your barrister to apologise on your behalf. Probably didn't want any of the managers to be cross-examined in the penalty hearing, so that might be the reason for that. I guess some of the details of what they did. So Qantas continued to sell tickets to cancel flights, and you can see 70,000 flights, 86,000 consumers, and then delayed notifying customers of the flight cancellation, 60,000 flights, 883 consumers. So it's significant conduct. It's quite extensive. I guess compared to their probably total customer base, it's quite small, but there's a lot of detriment here to consumers. The big enforcement action in October was the case against Optus, which has some similarities to the Telstra case run, I think, a couple of years ago now, where Telstra was found in some of the same regions, sort of northern parts of Australia, Northern Territory, to have taken advantage of vulnerable consumers, a lot of Indigenous consumers, and offering them products which were not suitable for them. And some actual alleged fraudulent conduct. And Telstra agreed to a penalty there of $50 million, which is a very big penalty. Another penalty is going to be paid. Here, the ACCC has alleged similar conduct against Optus. It is worse in some respects. It's a larger number of consumers are involved. 429 consumers were found or were alleged to have been the victim of this conduct. This may be the tip of the iceberg, and it's obviously representative. Could be a lot bigger. But if Telstra was fined 50 million for a lesser number of consumers, you'd expect that the baseline for the ACCC in the negotiations is going to be at least 50 million, probably more. I think it might be around $75 million penalty. Optus hasn't really said anything about contesting this matter. They furious apologies and seem to be willing to settle it. So it's alleged unconscionable conduct, selling goods to customers that they did not want or need, and in some case pursuing customers for debts resulting from the sales. And there's allegations that the customers were in positions of vulnerability, disadvantage, mental health issues, diminished cognitive ability or learning difficulties, financially dependent, unemployed, limited financial legal literacy. So that's not good, taking advantage of people who are very vulnerable. And also putting pressure on customers to purchase a lot of extra things that they couldn't afford, expensive phones, accessories, not undertaking required checks to make sure the customer could actually pay, and also selling people services that there was no coverage. That's pretty bad stuff. So that's an interesting case. It'll be settled, no doubt. I think the number is really the interesting thing. I'm picking about 75 million probably there for the penalty. The big merger that's been kicking around the ACCC for a while in 2024, and which I guess we all know now was ultimately approved, was Sigma Chemist Warehouse. And even though Sigma appears to be the quiet, it's a reverse takeover because Sigma's listed and Chemist Warehouse isn't. And Chemist Warehouse is a massive business and is a very successful company, and it wants to get listed. And really, I don't see any issues with this. It's interesting. One of the gigs I do have is I have these consultations with various merchant bankers, just an hour talking to them about this merger. I must have done about half a dozen of them at least. And every consultation I've told the merchant bankers that this merger is going to get through. It's not a breach, even though the ACCC said some pretty full-on things in its statement of issues, and the pharmacy guilds jumping up and down. It's just not a breach. There's really no overlap. I can see that's significant. It's Chemist Warehouse is moving into the wholesale space where it's not at the moment. Sigma's already its wholesale supplier. The banner groups are independently owned. So the Sigma has banner groups, but all the stores under those different banner groups, such as Amcal, are all independently owned. So I've been telling people it's not a breach. I said there might be some minor divestiture undertakings, but ultimately it's not a breach of the Act. And so the ACCC has put out in October, they put out some proposed court enforceable undertakings to get the merger across the line. The merger was raised some concerns with the ACCC. They issued a statement in June where they identified some preliminary competition concerns about the proposed acquisition, including at the retail level, the impact of proposed integration that result across the wholesale and retail level. A bit hard there because you just got to see a lot of efficiencies arising from that. I'm usually pretty sceptical of efficiencies, but you can see some definite efficiencies there. The ACCC concerns included potential harm to pharmacies currently supplied by Sigma. So obviously, they don't want to be competing against Chemist Warehouse Direct. Issues about confidential information going backwards and forwards. It's common ownership. And the undertakings that were proposed not to prevent or hinder franchisees who entered into franchise agreements prior to a certain date to terminate the franchise agreement and move to a different wholesale supplier, different banner group. So that's allowing the free movement of any franchisees who don't want to be under the new combined entity to move to either API or the other provider, who I've totally forgotten what they're called now. But basically, they're three wholesale suppliers, each have banner groups. API are owned by the Wesfarmers Group, and I think it's Synergy or something along those lines. So there's options for franchisees to move without penalty. To place restrictions on the use of confidential information. So that's important because they're going to have data about different competing franchisees under the banner groups. And finally, to remain a participating pharmaceutical wholesaler under the Commonwealth Government's community service obligation. That seems a strange one. Like, I couldn't see them bailing out from that obligation, but I guess it's always possible, and this way it locks them in for at least 5 years. But I just can't see them pulling the pin on that particular obligation. So another merger that was looked at, Lineage and Fremantle City Coal Stores, and this related to a Perth-based cold storage supplier, basically Lineage buying Fremantle City Coal Stores, and the ACCC concluded that this particular merger wasn't going to raise any competition concerns. This is a market that is quite concentrated, and there's quite a lot of high barriers to entry. I've done a bit of work in this area many years ago, the ACCC. But I guess the main thing here is other competitors in the market, and clearly Americold is a very big competitor, and there's other local suppliers who are going to be able to restrain the merged firm. So this one's been let through. Cube and Marat, this one the ACCC has concerns about. They announced some preliminary concerns about Cube buying Melbourne International Ro-Ro and Auto Terminal. So that's basically roll-on, roll-off, so import of vehicles to Australia, no export nowadays. And I guess the big thing here is Cube has quite a big business in the initial conversion of the vehicles to Australian standards. So when a vehicle comes in, it doesn't have the relevant Australian stickers and the compliant jacks and other products, and so that has to be done. So that's what they call PDI, pre-delivery inspection services. It's probably more than just inspection. They actually upgrade the vehicle so that it can be driven on Australian roads. So the ACCC was concerned that the acquisition may result in Cube, which is one of Australia's largest integrated terminal and freight logistics providers, owning a further interest in a critical component of the automotive delivery supply chain. So concern about vertical integration, that obviously raised issues about maybe preventing access to competitors, and have a significant effect on the competition downstream service, and that's what I mentioned before, the PDI. But automotive stevedoring, so I guess it's very simple with roll on, roll off. People just drive the vehicles on and off the boat. But yeah, obviously Cube has an interest there. So it's interesting what happened. The ACCC was provided with some proposed undertakings, which have also been put out to the market for comment. And effectively, they're extending some existing Court of Full undertakings, which are in place in other areas, Port Kembla, Port Brisbane, and it's effectively to stop AAT, which is the subsidiary that Cube owns, preventing them from discriminating between terminal use in favour of its own interest in the automotive supply chain. So that's an undertaking that it won't, discriminate, that it won't share sensitive price information, confidential information, and report on compliance with undertaking. There'll be independent oversight, independent audit. I don't know who does that. But one of the big firms, I don't know why people keep hiring the big accounting firms to do this stuff. It costs them an arm and a leg. A bit of a plug for myself. I do that work, and I definitely don't charge as much as those guys. Impose restrictions on AAT's ability to introduce or change certain tariffs. So it's a behavioural undertaking that's being proposed. Seems to have got over the line previously. It's likely to get over the line again. Accolade and Pernod. This is another merger that was signed off by the ACCC. Basically, Pernod Ricard Winemakers was up for sale, and Accolade has decided to buy it. I never really heard of Accolade, but it's a trading name for another company. And the ACCC concluded the proposed acquisition was not going to substantially lessen competition and looked at a few different markets: wine processing and packaging services. Similarly, unlikely to substantially impact competition, wholesale supply of wine. These are very competitive markets, so it's very unlikely this would result in a lessening competition. Also looked at monopsony buying power, the ability of these guys to maybe force down the price of grapes because they're buying so much. Again, the ACCC concluded there wasn't going to be any substantial lessening competition for monopsony buying. So they conclude Accolade is unlikely to have the incentive or ability, I think probably the ability, to engage in conduct, and that even if such conduct occurred, unlikely to substantially lessen competition. I don't know incentive. I think companies always have the incentive to try and lessen competition, but it's ability, whether they can actually successfully integrate or successfully carry out their strategy. A big merger that was signed off at the end of the month. And again, this is interesting, the way that the ACCC has announced it won't oppose acquisition subject to various court enforcement undertakings. So here, Brookfield, which has been very active in Australia buying various assets, wanted to buy Neoin. I don't know that's the correct pronunciation. It's a consortium, a consortium led by Brookfield's buying Neoin. And that company basically is based in Victoria and has a range of different energy projects, renewable energy projects. So you can see there, Neon specialises in renewable energy projects, has 15 operating assets in Australia and a further 48 projects in varying stages of development. So Brookfield wants to acquire this, and the risk was that Brookfield already owns AusNet, and which owns and operates Victoria's monopoly electricity transmission network and parts of the electricity distribution network. So there was a concern there would be an overlap between the two companies and give Brookfield as acquirer some market power. So as you can see, the ACCC was concerned that Brookfield, through control of AusNet, would be able to operate the Victorian transmission network to favour its own generation of storage assets and hinder rival generators of storage assets. So again, vertical integration concerns, restricting access. And so what's happened here, the ACCC has effectively signalled that it's going to let the merger through with some undertakings to divest some assets. So without this divestment, the acquisition would increase Brookfield's incentives, and that's really what it's about. It's not so much incentives, it's ability to delay or increase the cost of connections, works and rival projects, or operate the AusNet transmission network to benefit its related assets. And now, as part of the acquisition, Brookfield will be required to divest some of the target's operational assets and 6 further development projects in Victoria. And the operational assets are the Victorian Big Battery, I can't pronounce that, solar farm, and a few solar farms and battery assets. Now, the law firm that came through was the Treasury Law Amendment Mergers and Acquisitions Reform Bill. I'll do something separate on this, go through what the proposed changes are. I've just been flat chat busy and I haven't had a chance to get through. But effectively, it's bringing in a mandatory system. So in the past, people just had to, tell the ACCC if they wanted to about a merger, and that worked pretty well when I was running Sydney Mergers Asset Sales Branch. But it seems to deteriorated with a lot of mergers not being notified to the ACCC. There was a statistic showing that almost 1/3 of all the mergers that were probably significant weren't being advised to the ACCC. So people have been naughty, and that's resulted in a great, flexible, fast, voluntary scheme going under. So, but the mandatory scheme is common, like virtually every other OECD nation has them, with the exception of the UK and New Zealand, so pretty significant companies and trading partners don't have them. But it's probably the way to go, particularly if you can't trust people to tell you about important mergers. ACCC, first instance decision maker, there'll be appeal to the ACT, they'll have a much bigger role. The federal court's role is restricted, so in the past you could go to the federal court and get a declaration the merger wasn't going to breach the law. Well, that's gone, and probably appropriately so, because really ACCC was under the hammer to get their case prepared very quickly, and it couldn't do it. And lost some cases which I think in hindsight have been shown to have been breaches, but ACCC just couldn't muster the evidence quick enough, and that's not appropriate. Like, if this is important stuff, you can't be letting mergers through just because the regulator doesn't have enough time to actually prepare their evidence. The various thresholds were very complicated initially. They've been simplified now. They're still pretty complicated, I've got to say. And the thing that I pointed out once, and people just looked at me like a bit of a weirdo, initially the ACCC wanted a call-in power, and a lot of people were very against it, saying that's not right, you should have a call-in power. It's very common around the world for regulators to have call-in powers, by the way. But anyway, it got rejected by the ACCC, by the government. But then, I don't know, I won't say sneakily, but effectively the Treasurer does have a calling power. He has, or she in the future, has the ability to designate particular industries or even mergers that are below thresholds are subject to the new mandatory scheme. So there's a calling power. Maybe people don't care that calling power is exercised by the Treasurer as opposed to the ACCC, but clearly there is a calling power. It's just exercised by a different party to what was proposed initially. Authorisations, a couple of these were mentioned in the previous month of September, and it was like proposing in September to authorise these particular arrangements, and in October they actually formally approved them. So nothing really novel about these matters. Basically, there's this graduate entry medical school admission system which sort of allocates students to all different unis, and I guess there's various public benefits with sharing around the talents and underpinning the investments that universities make in medical schools. So that's been authorised again. That's previously was authorised. Then there's St Luke's Medical and Hospital Benefits Association. This is effectively an authorisation allowing St Luke's to price fix in relation to dental services, but effectively keep the prices down. So I guess there's a benefit there to consumers that pay less probably if St Luke's Medical, dentists and those participating in the scheme are all forced to charge low prices. I don't know if it's economically efficient, but it clearly is consumer welfare is enhanced by keeping prices down. Cash in transit's been going on for months. This is I won't go through too much detail, but effectively Armaguard looks like a basket case, and if they go under, then there's nobody left to make sure that cash is transported around the market and around different traders, such as, obviously banks, retailers, Australia Post. A lot of people rely on cash, and so they're desperate to try and think of some scheme to try and keep cash and transit services being provided. I don't know what they're going to end up with, but Armaguard, just got their hand out. Hopefully, for them, they're going to get a bunch of money to keep running their operations. A bit of welfare for Armaguard and Lindsay Fox. Pilbara regime. This is another one that was proposed to be authorised, and an announcement made in September, and it's finally been, well, not finally been, but it's been formally approved. Pilbara regime, never heard of this before, but apparently there's a regime in place to allow various competitors to work together in relation to maintaining and improving safety, security, blah, blah, blah. So that's clearly strong public benefits there. Inquiries consultation, air services. So the way this works is air services have to propose some price increases, go to the ACCC, see what they think. ACCC can say, yeah, we think it's okay, we think it stinks. But the key thing here is, whatever the ACCC says, it's not the final decision maker. Clearly, if they think it stinks, then the minister who does make the decision, which is the Minister for Infrastructure, Transport, Regional Development and Local Government, is unlikely to agree to it. But ultimately, the ACCC just investigate things, and this was a 6% proposed price increase in relation to en route navigation, terminal navigation, aviation rescue, and firefighting services. The thing that's interesting here is the price increases is found by the ACCC to be justified, but the evidence put forward by Air Service Australia was pretty pathetic, and they did make a mention in their press media release that in future they hope that Air Services does a bit more work to justify their proposed price increases. They properly allocate costs. They didn't allocate costs properly. So very, very amateurish, I think, by Air Service Australia. Well, there was a big speech given by Jenny Gottlieb to the Gilbert and Tobin Financial Services Forum, which I never heard of that before, but it's a good idea to bring together the financial services regulator. And it's an interesting speech. It covers a lot of issues, and I've just extracted all the titles. Opportunities and challenges of an evolving financial services sector. So she looks at that issue. Obviously, cost of living, consumer engagement, competition in retail banking markets, reiterates the fact that retail banking markets aren't very competitive. Even though they went down on the Suncorp ANZ merger, the tribunal did sort of agree that, well, it's not going to lessen competition because there isn't much competition, which is not good for the banking sector. They really have to compete a bit harder. Talking about the decision by the government to remove card surcharges, which is coming in 2025. Consumer data right, which has had a funny history. It was all full on, and then under the Liberal government, it was all full on, and then the Labor government pulled back on it a bit. It's really important to do this. It's just so valuable in terms of competition, but I guess the government's being convinced by all this complaint about compliance costs, and I think it's fair to say the compliance costs are pretty high. But the consumer benefits are also very high, and competition benefits are very high. So it's still going ahead at a reduced pace. Talking about enforcing competition law, they make some reference there to the MasterCard case, which seems to be going ahead to trial. There's a lot of preliminary skirmishes, but it's a Section 46 case. Talking about their merger law reforms, which are coming through, which obviously impact the financial sector significantly. Advocating for law reform, and they're talking about prohibiting unfair trading practices, which the government seems to have embraced and will be bringing in. And they make a reference there, hey, we should actually bring this in the financial services sector. Not too sure it's needed because there are other laws there about, that seem to be similar to the unfair trading practices. But anyway, that's a point that they make. Opportunities and challenges of digital economy, that's a big issue. Not so much related to the financial services sector. Disrupting and preventing scams is a very big issue. The Australian banking system is pretty behind the rest of the world in terms of combating these scams. There was a really interesting case recently taken by the ASIC against, I think it was Citibank, for not really implementing enough protections for the consumers in relation to scams. So this is a really hot area, and they really have to pick up their act because Australian consumers aren't being protected well enough. Navigating declining cash use in the economy, so that's all the stuff about armour guard, and that's a big issue, having to resolve that issue so that cash can still circulate in the economy. The future of financial service innovation and competition. I don't know, I guess the fintechs are bringing a lot of innovation to the markets. The big banks aren't bringing very much innovation or competition to the market. So I guess encouraging the growth of the fintech sector and protecting consumers in the face of climate change. Well, this is a lot of issues, I think maybe more in terms of reporting on ESG type issues, maybe more an ASIC issue. But clearly the ACCC is very interested in environmental representations. And the final thing is ACCC got an extra $30 million, which is over 3.5 years, so they're getting about $8.5 million a year to really assist them in their investigation and enforcement in relation to the supermarket and the retail sector. Hopefully they put it all in investigations because really $30 million in enforcement, particularly against Coles and Woolies, if they contest the case, isn't going to go very far. But if they put into their inquiries, hire new staff to really drill down on some of the pricing issues, it'd be really interesting. So that's a strong message to the market and to really Coles and Woolies that the ACCC's going to get to the bottom of any bad behaviour that's going on in the supermarket sector. I don't think there's a whole lot going wrong. I was really surprised at that case, the down and prices drop case. That was really dumb by the both of Coles and Woolies, and they really had to settle that ASAP. But I think a lot of the bad conduct that used to occur in the market, particularly when I was back in the ACCC, some terrible conduct back then. But really, they're probably not doing that much bad stuff at the moment. I don't think there's a lot of carrying on that they're doing terrible things, but really, I don't think, given all the scrutiny they've had over the last few years, I think a lot of the bad conduct's being driven out. So just a final commentary. Qantas settlement very significant. I guess Qantas sensibly settled it. Probably maybe a bit on the cheap side, like 100 million. Maybe ACCC could have got more if it runs a trial. But that's a really important case. It just shows that ACCC is willing to take on these cases, willing to press for a very high penalty. I think Optus is really bad conduct. Again, I don't know how companies see their major competitor getting nailed for particular conduct and don't immediately go out and check to see if they're doing the same thing. And this is what Optus was doing, the same thing as Telstra, and it seems to be worse. So why that wasn't picked up, I don't know how these people, they spend so much money in compliance, but I don't think they have people who get to the bottom of things very well. That's going to be a big one. I think 75 million, that's my prediction. I think it'll be settled. And I don't think you go to 100 million, given you got 50 million out of Telstra. Sigma Chemist Warehouse undertaking, well, we all know that's accepted by the ACCC, the merger signed through. The big thing here is, so many people were banging on saying it was a breach. And you just got to look at the fundamentals here, the level of overlap, what overlap is there, what are the ownership structures of pharmacies. You own a banner group, but you don't, and you don't own the individual stores. So there was really no breach here, and so many people were just banging on, saying things that were just false and misleading and incorrect. Pharmacy Guild obviously doesn't like Chemist Warehouse, I think, and doesn't like increased concentration, but fundamentally there's no breach here. So there's really, so much noise and false news around this merger. Merger reform significance, see how it pans out. I think, I think the suggestion there's going to be less work for the ACCC is wrong. I think there'll be more work for the ACCC. Clearly, if there's 1,000 mergers coming through and they're being engaged in by big companies, then there's going to be more work for the ACCC. The idea there's going to be less is I don't know where people get that idea from, but it's going to be less. I guess the merger approach that ACCC takes is really interesting. If you see a lot of the mergers, it's sort of, they look at a merger and then maybe somebody realises some issues and makes a divestiture proposal straight up and they put it out to the market. Obviously consulting on behavioural undertakings, really getting a lot of mergers through based on some tweaks or significant changes to the merger. The out-and-out opposition to mergers is becoming a thing of the past. I think most businesses realise that there's a way of getting a merger through by selling a few assets. Sometimes it might actually be beneficial because the assets might be non-core, and you're seeing this more and more. And this is what's really interesting, that divestitures in merger scenarios make perfect sense. It's sort of saying, well, we'll let the merger through because if you don't sell these assets, you're going to have a substantial degree of market power and you're going to have substantial less competition. So we have to remove that substantial degree of market power from you by forcing the sale of these assets. The same thing seems to apply in a 46. If somebody's found to have a substantial degree of market power and they're using it to damage their competitors, it seems sensible to try and remove that substantial degree of market power, and that seems to justify divesting assets to remove that. So the whole idea of divestitures in this context, Section 46, makes, I think, perfect economic sense. And it's just a shame that the federal government seems to have just kiboshed the whole concept at a very early stage. So it was a quiet month in the sense of the number of media releases, but as you can see, some big stuff there. Qantas, Optus, Sigma Chemist Warehouse undertaking, and merger reform. So it was a big month. So that's all I have. Hopefully that's been helpful. And as I said, I'll start to catch up. If you do have any questions about this presentation, feel free to send me an email or give me a call. Bye bye.